Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. Today I want to talk about the process server's and buyer's remorse. Now, the scenario is as follows. You filed a lawsuit against your wife for divorce because you had this horrible fight. It's been culminating for a long time. You know how bad it's been, and you decided finally you're hiring a lawyer. Your lawyer has drafted papers. Your lawyer has filed papers, put them in the hands of a process server. Process server has knocked on your door and handed those papers to your wife, and now you changed your mind. You decided you don't want to go forward. You decided you want to go into counseling or something like that, or whatever. You don't want the divorce. What do? Well, there's a couple of issues. You see, once you serve the other party, the clock is ticking, so to speak. The court's already involved. Jurisdiction has been taken of this case by a judge. The other person's been served, so now they're within the jurisdiction of the court, so certain things have to happen. If you really don't want to go forward with it, you got to contact your lawyer. If the other side hasn't filed an answer, your lawyer can file a petition for a voluntarily dismiss the case. A petition to voluntarily dismiss, and that motion for voluntary dismissal is something that can be done, and maybe you can get it under the radar before the other side files an answer. If the other side hired a lawyer and they filed an answer, at that point it's not so simple. If you want your case dismissed, you got to file a motion to dismiss it. And you got to get consent to the other side. The other side may consent or may not consent. The other side may consent, but say, look, I spent all this money on lawyers, you got to pay my lawyer. You know, there could be conditions to it. If the other side filed a counterclaim in answering your case, the fact that you now want it dismissed doesn't matter. It doesn't stop that train from going down that track because it will proceed on the strength of the counterclaim that the other side filed. So you're pulling your claim away doesn't stop it. So these are things you've got to know. There are repercussions too with starting and stopping your case. Number one, you're spending money on your lawyers. Don't think for a minute that if you retain a lawyer and he opens up the file and he opens it up in Drive and he opens up the file for billing purposes, the case is put in a lawyer's docket, he drafts the file, he serves it, he does all this stuff, and you're changing your mind. One of the repercussions is you're going to get billed for it. You're not going to get your retainer back, and if you get it back, you're not going to get all of it back because all the work that's been done. Lawyers are set up to do work. They're hired and they do the job. They're not set up for a situation where people come, get the thing started, change your mind, rechange your mind. That's not a system that is in the normal course of the business of the lawyers. So one of the repercussions you're going to see if you start and stop is you're going to see that it becomes expensive to do it, because if you change your mind again and want to restart, you expect to be asked to re-up on your retainer because the money that you've already spent may be salvageable or may be gone and the work has to be redone. So there are repercussions with deciding start and stop, changing your mind. Therefore, my advice is don't go to your lawyer and hire your lawyer on a whim. Don't go to your lawyer in a fit of rage and decide you're going to start your case. Hire your lawyer after you've made a calm, collected, and appropriate decision that there is no way out and this is what you're doing. Because if you act in the heat of the moment in hiring your attorney, it's going to be an expensive decision, and when you stop again, start again, you lose credibility before your lawyer and before the court. And it's not good to do that. If you have questions about that, reach out and we'll be glad to help you out.